For 5 years, the Integrity Commission has been investigating Dr. Andrew Wheatley. And at the conclusion of the investigations, they have recommended that he is to be charged for 1, making false statements in his statutory declarations, 2, for failing to provide information requested of him by the Director of Information and Complaints, and 3, illicit enrichment. Now, I need you to hear me out on this point because I think it's an important point to make, and I sincerely hope that this information gets to the ear of the Integrity Commission. Now, the 3 allegations were sent on referral to the Director of Investigation from the Director of Information and Complaints. And you remember, it's that Director of Information and Complaints who receives the statutory declarations from the clearance. 2 of the allegations that he made false statements on the statutory declaration and that he may own assets disproportionate to his lawful income. They went on the same referral on March 29, 2021. So that was when the investigation would have, commenced, so to speak. The 3rd allegation, that he failed to provide information that was requested of him, that one went on a 2nd referral on February 24, 2022. So the Director of Information and Complaints had asked him to provide certain information, and he failed to do so in the timely manner. And for that reason, he was referred again to the Director of Investigation. When you look at those particular 2 offenses, the making of the false statements on the statutory declaration, for instance, that would occur when the investigators found out and can prove that you own an assets. And when they check the statutory declarations and found that you did not declare it, that is when that offense arises. And that offense would have arisen and referred to the Director of Investigation March of 2021. The process is that once they alert you that you left this off, you are supposed to submit an amended statutory declaration or declarations, depending on how long you left it off for, and submit it. For the life of me, I cannot imagine why such a simple, provable offense where you have the evidence that he did indeed own the assets and he did indeed left it off his statutory declaration. Why did they not charge him for the offense at that time? When he was asked to amend his statutory declarations to reflect the assets, was he told at that time that he was going to be charged for the offense? And if he was not, why not? And if he was, why not charge him? Why wait until the completion of the illicit enrichment investigation to come now and charge him for something that happened 5 years ago that was corrected? Why wait so long? I'm of the opinion that maybe there should be a time limit for when persons can be charged for offenses such as these, not the illicit enrichment. That may take time to investigate, but there's no requirement for any further investigation into these particular offenses, because I don't think it is fair to the people that you should be looking 5 years later to come charge them for something for which there is absolutely no good reason why they should not have been charged at the time when the offenses were committed. And so the Integrity Commission needs to have a look at this. Charge the individuals at the time when the offenses were committed. That is my view. What this is really telling us, is that the Integrity Commission is a very amateurish organization. Very amateurish. And I hope this matter falls into them ears and them look into it and do something about it. Because in my view, this is manifestly unfair. And we're not just talking about Andrew Wheatley. Anybody else them doing it too. It is manifestly unfair to them too. And that is my argument. So that is the first problem that I have with the Integrity Commission. I mean, they simply just can't get the thing right. They just cannot get the thing right. Basic, simple thing like this, and them can't get it right. When it comes now to the matter of the report, I want to bring to everyone's attention something that I noticed about this report that was submitted by Kevin Stevenson, the Director of Investigation. I want you to take a look at the date in which this report was completed. His report was completed March 20, 2026. When was it that the Integrity Commission submitted the report for tabling? June 11, 2026. A full 83 days later. And I mention it because when I delve into this report and start to point out some things about the report, which is different from the report, for example, when they had conducted their investigation into Andrew Holness's affairs, this report is completely different. It was heavily redacted. Accounts with banks, and we don't know the difference between the accounts. We don't know what was savings and what was checking. Perhaps they think that that was not important. When it comes to land matters and titling and so on, these are public information. These are not information. If you go to the titles office tomorrow and ask them for a title, even for the Prime Minister's house, they can't tell you, so they're not giving it to you. And they can't tell you, so them can't tell you and ask you what you want it for. These are public documents. The Integrity Commission, for some strange reason, decided to redact the information pertaining to real estate properties that Dr. Wheatley owns. And they cannot claim that it is for privacy reasons because there is no privacy whatsoever in the ownership of land in Jamaica. And if they think there is, tell them to show me which part, right? I am sure no law couldn't tell you that. Because if the law told you that somebody owning property in Jamaica is a private matter, then it means to say that when you go to titles office to ask for any title or go online, you can't get it because it's now declared privacy. They did, however, continue to tell us about the names of companies and businesses that he owned and the shareholders and directors in those businesses. But for some odd reason, they decided not going to tell us the volume and folio of the properties that he owns so that we can go and check to see if what they're telling us is true. What was the reason for hiding the information about the properties that USM own? What is the location, the name, and the volume and folio of the property you own in St. Elizabeth? Where you hide that information for? For what reason? Contrast that to Andrew Holness's investigation, which to my mind was an excellent investigation. I said that at the time, despite the fact that the conclusions that the director of investigation came to, I may have disagreed with his conclusions, looking at the same evidence as him. That's how it is supposed to be. Now, if you're going to argue that since the law says that you should leave out matters that may prejudice the case, chances are the matter will be put before a judge. And the matters put before a judge is not quite the same as matters put before a jury. And even if there is a jury, so what? You're submitting information to the parliament about one of their colleagues. The parliamentarians as well as the constituents are entitled to know what it is that you say you're charging the man for. And this is something that was set out in the law itself that set you up. That your investigation report, which would have been an investigation report for the police, but the police investigation report, they go to the DPP, and there are rules governing that. But your investigation report is supposed to go to the parliament. So therefore, you have to be clear, except for instances when, you know, the revelation may prejudice the case or it may injure some third parties' privacy, right? If you make that this determination that that person is not involved, or maybe they ask you not to mention them name, for whatever reason, you can make that call. But when it comes to the properties that people own that you're investigating, you can't leave that out. And who you're leaving it out for? The public, the parliamentarians. So your report that you send to the parliament is not complete. Furthermore, there is the matter of injury to these persons who are our civil servants, politicians, whatever they are. And since we have an opportunity to see your investigation and it's transparent, and you talk because you're talking to Wheatley, you're telling us this is evidence, and these are my conclusions based on this evidence. You collect the evidence, and that is always good. Your conclusions, though, may not be all that good, but that's all right. You're entitled to your own conclusions, right? So when the information is being gathered into a report, you need to put the information there so that the people can do them cross-checking and double-checking and triple-checking if they want to. Transparency, that is what the system was set up to facilitate in order to protect the reputation of people. And despite the fact that you went to so much effort to conceal so many information from the public, you see how long it took me to come out with this video? I was shocked, no, and when I saw that report, shocked out of my wits for days. You can ask the people around me. Every time I think about it, I say, I can't believe it. I cannot believe that the Integrity Commission put out a report like this. It was poorly written, riddled with mistakes. And for the all intents and purposes appear to have been rushed. And the mere fact that after that report was written, UNO take 83 days before the Senate to Parliament would suggest that UNO had problems with it too, perhaps several problems, and UNO requested that the original report that it intended to put and send before the Parliament was amended. What else and what other reason could it have been? It could never have been in order to get the indicative ruling, because based upon that indicative ruling, I don't think that that director of corruption prosecution took much time in coming to fair conclusion. She saw the evidence and so she made up her mind. And the charges that were referred to her, she decided that she thinks she can win it in court. That's how she should approach it anyway. So this report, in my view, is a disgrace and it is not a credit to the Integrity Commission. Not at all. There is another curiosity about this particular report, and I sincerely hope we never see a report like this again in future. The report purports to be investigating Dr. Andrew Wheatley's statutory declarations from 2013 to 2022. In fact, it was supposed to have been from 2010, but evidently the bank that Dr. Wheatley banks with, they don't have no record going back so far. So that is why they had to commence their investigation from 2013 to 2022, inclusive. So that is a 10-year period. And what they did, much to I couldn't get over it when I saw it. What they did was, instead of reporting the statutory declarations as they had come in year by year, they decided to total up the assets, income, and liabilities over the 10-year period into one and then present that information to you. And the question is, why would they have done that? And it would have been when the report was being drafted that the decision would have been made to amalgamate all of these 10 statutory declarations into one and then refer to the period that they covered as the relevant period. That could have been a decision that was made because of how small the amount of money was that they were investigating. They talk about Andrew Wheatley having income of $187 million. Well, if you divide $187 million by the relevant period, 10 years that they covered, you get $18.7 million a year average. You heard what I just said? Yes, my people. It was a 10-year period that they were covering. So they took the statutory declaration of 2013, whatever he said that his income was in that year, and then added to the income of the 2014, added to the income of 2015, all the way up to 2022, and get the total of $187 million. Whether it was their intention, yes or no, the effects of what they did was to obscure the true financial position of Wheatley by amalgamating his statutory declarations in this way. For example, you may believe that somehow this man has accumulated a massive amount of wealth over the period. If this was their intent, then it is reasonable, in my view, to describe their actions as malicious and deceptive. If, on the other hand, that was not their intent, they may have been motivated into the action by other reasons. Reasons, of course, of cowardice. I am more swinging with the view that maybe it was cowardice and they were afraid of what it is we would say when we find out that them spent 5 long years looking into statutory declarations of a man who is earning $18.7 million a year. For goodness sake. For goodness sake. His salary was $5.1 million. He had investments that was bringing in money. And the total amount on average was $18.7 million in income, including his salary. That's not a lot of money. Then there's the assets and the living expenses that total $351 million. And so you're talking about now an average of $35.1 million a year. That's not a lot of money. So them took 5 years on this little bit of money. And maybe them knows that we out here going to spot it and start to ask questions and raise backside about it too. And so it's possible that the real reason why they chose to conduct the reporting in this manner was to cover them asses from the public backlash that they anticipate they would have gotten had they reported it in the usual manner, year by year. It is also possible that the decision that they took was arbitrary. They just decided that that is what they want to do this time around. Might save some time. But I don't know if that even make it look good on them, because it would suggest that they're not thinking. And the positions that they hold requires them to think and make sure that the decisions that they take can stand up to public scrutiny. And in this case, I am very sorry to have to say, it no look good. No look good at all. If you ask me what is my view, is it that they intended to damage Dr. Wheatley, or is it that they were trying to cover them own asses? It may be both, but I would lean more on the idea that they were trying to cover their asses. It is very doubtful, though, in my mind, that they did not recognize that the step that they were about to take would have damaged Dr. Wheatley. I do not accept that. And this is what leads me to the conclusion that their action is either reckless, corrupt, or both. Now that the Director of Corruption Prosecution has indicated that he should be charged for 3 offenses, the question now is just how much problem Dr. Wheatley has found himself in. So we now turn to the law and hear what it has to say. One of the offenses was failure without reasonable cause to provide information, and the penalty is a fixed penalty in the amount of $250,000. And on top of that, whatever information they had asked him for, he will have to submit them. And it is only after doing these two things that he would have discharged himself of the liability to be convicted. Meaning to say, the law say you give him a chance. And this is Section 43.3 of the Integrity Commission Act. To discover how much problem Dr. Wheatley is in terms of the false statement, we have to turn to another act. It is the amendment to the Contractor General Act, and it says at 29, every person who willfully makes any false statement to mislead or misleads or attempts to mislead the Commission in the execution of its function, in the execution of its functions under this Act or without lawful justification or excuse, obstructs, hinders, or resists the Commission in the execution of its functions under this Act shall be guilty of an offense and shall be liable on summary conviction before a parish court to a fine not exceeding $5,000. So, in addition to paying $250,000, Dr. Wheatley will also have to pay $5,000 for the false statement offense. So the damage of these two offenses is to Dr. Wheatley's pocket. Is in pocket that going to get the hit to the tune of $255,000. But when it comes to the offense of illicit enrichment, different story this. This is a more serious matter. And to find out just how much worries Dr. Wheatley is in, we have to turn to another act, the Corruption Prevention Act of 2001, Section 15.1. And it says, any person who commits an act of corruption commits an offense and is liable on summary conviction in a resident magistrate's court, in the case of a first offense, to a fine not exceeding $1 million, or to imprisonment for a term not exceeding 2 years, or to both such fine and imprisonment. But this is only if they bring the matter before the RM court. If they were to bring the matter before the circuit court, is another matter altogether. If found guilty in a circuit court, in the case of the first offense, to a fine not exceeding $5 million, or to imprisonment for a term not exceeding 5 years, or to both such fine and imprisonment. So that is the extent of the problems that Dr. Wheatley has found himself in. The official decision taken by the Integrity Commission is that Dr. Wheatley should be charged for, it says here, 4 offenses, but it amounts to 3. 2 of the offenses, 1 and 2, relates to the same thing, making false statements in his statutory declaration, but they fell under 2 different acts. The Integrity Commission Act came into being in 2017, but before that, you had the Parliamentary Integrity of Members Act, which was passed in 1973, and for part of the statutory declaration reporting fell under that act. That is the reason why they had to split it in 2. For the offenses that took place after 2017, that comes under the Integrity Commission Act, and for those offenses that fell under the Parliamentary Integrity of Members Act, they have to be tried under that particular act and what it had said at the time. And that is the explanation. The second offense that Dr. Wheatley is being charged for, it's kind of convoluted, but it says failing without reasonable cause to provide, it ought to say to provide information as the Director of Information and Complaints required. And that, of course, is contrary to Section 43.1b of the Integrity Commission Act. And the third offense that he's to be officially charged for is illicit enrichment, contrary to Section 14.5 of the Corruption Prevention Act. As I said before earlier in this video, the first 2 offenses, making false statements and failing to provide information, when we look at the evidence, Dr. Wheatley is as guilty as hell, and there is no doubt about it. So we are going to leave those 2 and focus our attention on the more serious offense, illicit enrichment. And it is to this offense that Dr. Wheatley says that he is innocent. And we are now going to check it out and see who is right. Is it the commission or is it Dr. Wheatley? The first thing we're going to turn our attention to is the income and liabilities of Dr. Wheatley, as is mentioned in this report. And what you're looking at here are 5 loans that he had taken out that he had failed to declare. Now, we're not going to be discussing the false statement, but it is significant, these 5 loans, because his failure to declare had a ripple effect on future events that unfolded. When he was asked the reason why he failed to declare these loans, his response was that the loans were not for his own personal use, is basically what he was saying. He had taken out these loans for the development that he was engaged in. And so it was for that reason why he did not declare it. He could not be more wrong. The loans, first of all, were in his name. And from the sitting in of your name, you need to declare it. He ought to have declared, therefore, these 5 loans totaling $53 million as a liability on his statutory declarations. But he never did. And so the money, of course, was deposited in his bank account. What the Integrity Commission saw was a spike on the income side. But it was when they had done their net worth analysis on the statutory declarations that they realized that something was off. Net worth analysis, by the way, is when they take the total of your income and your assets and then minus that from your total liabilities. And what you get is your net worth, which is your real, true financial position. So if argument's sake, you have assets and income totaling 10 million, but you owe 7 million, then your net worth is $3 million. That's all that means. And here now is where they're explaining to us at 4.515. Initially, a net worth analysis was conducted based on the information provided in these declarations. This revealed unexplained growth in Dr. Wheatley's net worth in 2010, 2011, 2014, 2017, and 2020, with the most significant unexplained growth occurring in 2011 and 2014. And you remember what happened in 2014? He had borrowed $10 million and did not declare it. So it would have showed up in his bank account, and there was nothing to say in his declaration that this was a loan. So therefore, what all they saw was the spike, the increase, the unexplained increase. Unexplained meaning to say it never said what caused it. And once there's a spike, questions are going to be asked. And questions were asked. And that was when they discovered from him, I do believe, that he had borrowed and that money that he borrowed was not declared. So the effect of not including it in his statutory declaration is that when he deposited the loan in his bank account, it showed suddenly that he had a net worth that increased by the amount of money that he put in the bank account. And as them look through the statutory declaration, they don't know what changed, apart from the fact that more money went into the bank account. There was no explanation as to what this money was and what it was for. And that, of course, raised the alarm. And that was why he found himself in the position that he's in, where they start to examine every damn thing that he had declared from 2013 to 2022. In examining his statutory declarations, the commission found that he suddenly started to declare some apartments. And when they checked it out, they found that he had owned the apartments for quite some time, but did not declare. So what you had was a situation where his assets were understated and so too were his liabilities. But there was an increase in his bank account, and that increases net worth, which raised the alarm. So the problems that Dr. Wheatley has found himself in were entirely of his own making. Dr. Wheatley's problems were further Dr. Wheatley's problems were further Dr. Wheatley's problems were further compounded by an analysis that they had done on his assets. It said at the bottom, the Director of Investigation also observed that during the relevant period, that is from 2013 to 20, 2022. Dr. Wheatley reportedly acquired property and other assets locally and overseas at significant cost, despite not having any reported accompanying liability, declared disposable income, and bank balance to support this expenditure. Now remember, all of this observation was based on the state of affairs where his statutory declaration was chaka chaka. He was not declaring all of his income and he was not declaring all of his assets. And because of that, they saw where him a buy property of foreign and said, but wait, but in bank account not showing same have money to do that. So where is this money coming from? Them don't see where him even borrow on those property to say, okay, so maybe he gotten a loan. And so that also raised them eyebrow and made them suspicious. And them decide now that they needed to dig, which is what they said below. These observations suggested that further analysis was merited. The Director of Investigation therefore moved to conduct a more detailed examination of Dr. Wheatley's income, inclusive of loans and assets acquired using the source and application analysis methodology. Unlike the net worth analysis, this considers the legitimacy of the source of the income and how it is used to acquire assets over a specified period, what he calls the relevant period. As stated above, and having regard to the Director of Investigation's findings in respect of Dr. Wheatley's net worth statement, the relevant period was deemed to be 2013 to 2022. So now it means because of the suspicious look, they decided they needed to do some more digging. They were now going to look at his income and expenditure in terms of the source of income. They want to now determine whether or not the income that he used to buy these assets were legitimate. Now that we understand the pickle that Dr. Wheatley has found himself in, let us now look at the information that the Integrity Commission gathered and what it means. When they had discovered the discrepancies in Dr. Wheatley's statutory declarations, they had used the net worth analysis methodology. Now they're using a different methodology that they call the source and application analysis. And what they're doing here is that they're looking at all income that is available to Wheatley and what him spend them on. So the source is the income and the application is what him spend the income on. And then now they're going to be asking him for the source of the funding. And I need to explain this to you because in this exercise, it is the legitimacy of the source that they are looking at. Therefore, any source that does not appear to them to be legitimate, or you cannot explain to them and show them proof that it was legitimate, they are not going to include them as part of your income, which is going to put you in a very bad position. And that was precisely what happened to Andrew Wheatley. Unlike Kevin Stevenson, the Director of Investigation who prepared the report that was tabled in Parliament, I am not going to begin my analysis from the assets and the liabilities as he did and analyze the assets and the sources accordingly. But I am going to begin my analysis of the IC's analysis by looking at the deposits first. Why? Because it does not matter where the investigator look. At the end of the day, he has to come to the bank accounts and look at the deposits. And do you know why? Because those deposits represent the income of Wheatley. So he has to come back there and he has to go through the deposits, list them, and ask Wheatley one by one what was the source of this income. The onus is on Wheatley to explain the deposit to the satisfaction of the investigator so that he can put it into his income column and not minus it. If he cannot explain the source, then the director of investigation will not credit him with the income. And that, I don't have to tell you, is problem. And so I believe in understanding what's going on with this investigation. This is where we need to begin. So under the heading deposits, it reads, the Director of Investigation examined 4 personal bank accounts held by Dr. Wheatley. The total deposits across the 4 personal bank accounts held by Dr. Wheatley amounted to approximately $595 million for the relevant period. So that's an average of $59.5 million over the 10-year period. We're going to skip from here, and then we're going to now look at his source and application analysis. And it is very important for you to write down this figure of $595 million. Yes, and it's going to be very telling. And what it will reveal is the answer to the question, should Dr. Wheatley resign or should he stay? This is Table 4, Source and Application, covering period 2013 to 2022. And we're going to ignore for a moment that they have accumulated all of the 10 years into one. We're just going to focus instead on what we have here. Now, on the left-hand side is the source, the income that was deposited in his bank account. That is where all the information came from. And on the right-hand side is what he spent his income on. Let us look at the income side first. You will notice that I have at the top, it says inaccurate, omitted vehicle sales, 4 apartments sold, and the rent was understated. We are going to ignore the 4 apartments that were sold and the understated rent. But for certain, the Director of Investigation had forgotten to put the vehicle sales in this mix. So the income is more than it is stated here, but that is not the relevant point. The first thing that he mentioned was the bank accounts, and he mentioned the opening balances. Now, how we arrive at that? Obviously, it must be the opening balances from 2013, right? Because he's not doing it year by year, he's doing it over a 10-year period. So the opening balances in the 4 accounts that Andrew Wheatley has would have been $4.8 million. They then added the loans that he had left out, $78 million, investment proceeds, $18.9 million, insurance policies, salary and allowances, $51 million, interest on accounts, rental income was only stated at $8.6 million. And when you add up all of that, they are saying that his total known income was $187 million. And it is very important that you make a note of that, because remember, what was deposited in his bank accounts as his income was actually $595 million. And yet what the Integrity Commission has here is $187 million. And you will soon see the reason why. So when we look at the application side, what was that $187 million spent on? You see the closing balances. That would have been, I imagine, the closing balances of his 4 accounts at the end of 2022. He then repaid his loans, had an investment that he had bought of $3.7 million. He bought properties for $48 million and motor vehicles for $10 million. And his expenses was $176 million over the 10-year period, which meant that his expenses was about $17.6 million a year. And when they add up that, they got his total known application as $351 million. Now, how they do this calculation? They look now at your income and they look at your assets and they're going to minus it. And if your assets come out on top, where you have more assets than the income that you made over the period, then that now is where them have reason to believe that illicit enrichment took place. And as you can see in Andrew Wheatley's case, his assets far outstripped his income by $164 million. I need you to make a note of that figure. It is very, very important. Andrew Wheatley had deposits of $595 million, which represents his income. And yet, the Integrity Commission has it here as $187 million. The question is why? What happened? Why did they only credit him with $187 million, which now puts his finances out of whack? And so we have to return to the information on the deposits. So it said that he had approximately $595 million deposited in his account over the 10-year period. It went on to say, the Director of Investigation sought explanations from Dr. Wheatley for each deposit across all accounts. The responses in this regard were provided by Mr. Dabdoob, and he was the counsel acting on behalf of Dr. Wheatley. So Dr. Wheatley apparently never take this thing serious to respond himself. Himself him lawyer. The part that I've circled, it said, the Director of Investigation notes that the explanations submitted by Dr. Wheatley were thoroughly examined and subjected to due diligence checks. Everything him told them went and checked for verification. Deposits for which the explanations were deemed satisfactory were deducted from the total deposits. The Director of Investigation also highlights that deductions were made for deposits related to passbook net, debit corrections, credit interest, and intra-bank and interbank transfers. So what are they saying here? As I said before, everything that they were told by Wheatley, every explanation he gave for this deposit, what was his source of income? That is the explanation that he was to give. They went and them check it out. So if him say, yes, man, Tom Strokes gave me this money because I sold him so and so, they went and them check it out. Or they ask him to provide evidence, receipts, contracts, agreements, and then something there. And he either supply them or they went and try and find out information on their own by finding the person, right? So after they ask him all these questions and did their verification, anything at all that he said that they could verify and he could prove to them that this was what the source of income was and it was legitimate, then take that out of the $595 million and put it one side and say, okay, legitimate money this. And then they add them up at the end of the day, and what they got was $187 million. And why did they get that? Because Andrew Wheatley did not fully explain the deposits that he had in his account, and very likely it was because of the length of time. He may not remember, and he may be like me. After a period of time, I may feel so the taxman now go come for them receipts, me dash them out. Quite unlike Andrew Holness, who hold on for him receipts even as far back as 1998 when him just come in a parliament. That was how he was able to defend himself against all them questions that they were asking about the source of income. He had them put down. It is obvious that either Wheatley did not keep proper accounts, or after he met the statutory declaration and he paid his bills, he probably fling with the record. Remember, your bank account can always verify anything that is coming in or out. I fling with my receipts them and so on, right? Relying on the bank account. But I am begging all of you that's supposed to deposit statutory declarations with the Integrity Commission, make sure say uno no fling with no receipt, find space and find folder, put them in and put them down. Because you never know when I'm going to come and ask you what is the source of this and that. And if you don't prove it, you're going to find yourself in trouble. I just saw it set. But here is the bombshell. An analysis of Dr. Wheatley's bank accounts, however, revealed that total deposits to said accounts for the relevant period amounted to approximately $595 million. The DI, therefore, subtracted the accepted explanations submitted by Dr. Wheatley, inclusive of those deposits not explained by Dr. Wheatley, but verified by the DI, along with deposits related to pass book net, credit interest, debit corrections, and interbank and intrabank transfers to avoid duplication of amounts. The total unexplained deposits amount to approximately $168 million. So he could not explain to them to their satisfaction the source of $168 million. And by satisfaction, he had to show them proof. Not just tell them, show them the evidence. Now, is this a coincidence or what? Because I needed to make a note of that figure. Because when we go back to the table 4, I made some little scribblings so you can see it clearly. When we look at the source and application covering the period 2013 to 2022, where the DI accepted $187 million as his legitimate source, and at the bottom it says he could not explain $168 million. And remember what we mean by explain. Not only is he required to tell the DI where the money come from, he had to back it up with proof. He could tell them where the money come from, but my impression is he never have all of the evidence to prove where it came from, so them set them there aside. $168 million was unexplained. And look at the amount that his assets exceeds his income by. $164 million. What does that mean? And I see you at the edge of your seat and your eyes up in the ear. And if you're doing something, you stop. For those people who support Dr. Wheatley, and for the other set that want him head, I see you sitting at the edge of your seat and the eye pop right open. And you look very worried because now it look like your credibility gone. No, man, your credibility not gone. You simply never read something and understand what it was saying. Because if you did, I am sure many of you wouldn't be out there talking the things on our chat say. And this also explains why it is that Andrew not let him go yet. Because them clearly went and looked at the numbers and they had an interest in understanding what they mean. Had Andrew Wheatley had been as meticulous and careful as Andrew Holness, he would have had his receipts and all him contracts and his thing put on one side. And when the DI came calling, he would have plucked them out and show him all the evidence. And he would have then been able to explain the $168 million. And it would have been added to his income. And when you add the 187 million to 168 million, what you get is $355 million would have been his income. Take that away from the application of $351 million, and what do you get? That his income, in fact, exceeded his assets by $4 million. His bank accounts are reflecting his true financial status, which is, once again, that his income exceeds his assets. Now, whether we can call all of his income legitimate income depends entirely on Andrew Wheatley. He needs to knuckle down and chase down the whole of those income that was rejected by the Integrity Commission and find the evidence, bail back the accounts. You said you had tenants and evidently you had them on a month to month, which is not unusual for somebody who has every intention to sell his apartments. You don't want to encumber it with a leased tenant if somebody come and say they want to buy it, and especially in circumstances where they made you an offer you cannot refuse. So in these circumstances, an owner with an intention to sell them an apartment or house, they will rent it month to month, and that is legitimate in Jamaica. So he may not have lease agreements, but what he ought to have are the rent receipts. But if he's the type of person who fling away the something, them after the tenant gone, tenant don't owe him nothing, and everything good and go fling them away, then now him in a problem. He's going to have to chase down them tenants and see if them have them receipts, or at least prepare an affidavit for going to help him out of court. Right? He said he never remember some of the name of the tenants, because had he been able to provide the Integrity Commission with the names of the tenants, them going to chase them down themselves and ask them, and they would have said, yeah, man, I was paying such and such, I lived there for such and such a period, and then they would have been able to build the account themselves. Right? Now, where can Andrew Wheatley go and get the names of those tenants? If he was a smart man and ensure that tenants get them light meter in their own name, then the JPS would have the letters that he would have sent to them, giving them permission to put the meters in the tenant's name. So he can write to them and ask them, they're going to do, see if you can find the copies of them letter and send it to my lawyer. And once them have that information, they now will have the names of the persons, and them and the IC can go chase them down and see if they can fix out that problem. As for the other income, he just will have to chase them down. Because if he cannot chase them down and the onus is on him to prove that the money was from legitimate source, it's not on the DI. If he failed to chase them down, sorry if you have to say, dog nyam supper. But on the face of it, his income exceeds his assets. That's all we can say at this point. Had he been involved in hanky-panky, then he would not have been in this position. What you would find, he would have accepted cash money and go buy assets, right? And then now you would end up with a situation where money don't pass through the bank account. But in this case, the money passed through the bank account covers his assets. And that is the point that I'm making. So no, Andrew Wheatley cannot go yet, but he needs to do what he has to do in order to clear his name. And that means him have to knuckle down and get to work and find the information to prove that the $168 million was from legitimate source. And that's all I have for you today, folks. So until next time, please remember to give the video a thumbs up and share the video, because this, I'm sure, is important information. So please share the video, give the video a thumbs up, and leave your comments in the comments section. Until next time, take very good care of yourselves and walk good.